Good day everyone. This is Agni Chaudhary from trustdeed.com, and the topic for today's webinar are the related party rules recently announced by the ATO in PCG 2016/5. To get a context to this discussion, the ATO believes that over 22,000 super funds may be affected by these guidelines, which somewhat explains why this topic has had such an overwhelming response. We've had more than 270 attendees who have registered so far, which is by any standards quite impressive. My purpose will therefore be to do justice to this piece of guideline and hopefully shed some light through the tunnel. But before we proceed any further, I'd like to remind you that I've uploaded some handouts that you can all refer to during the course of this conversation. I'd like to begin here by explaining that these guidelines provide explanation on what might be construed as non-commercial terms for related party loans. According to me, these guidelines are equally important for SMSF trustees that have already entered into LRBAs and looking for a possible course of action, and also SMSF trustees that are considering entering into LRBAs that are not financed by a bank. And in case you miss something, I also need to remind you that these videos are uploaded in the technical videos section on trustdeed.com.au and onlinesmsaudit.com.au. So let's now begin the discussion with a standard disclaimer. I'll read this out for you. The material presented in this presentation is distributed as an information source only. This presentation does not give legal, business, accounting, taxation, financial planning, or other professional advice or services, and material in this presentation should not be relied upon as such. The information provided in this presentation is general in form. Formal legal, business, accounting, taxation, or financial planning advice should be sought in particular matters. Deed.com.au does not accept liability in respect of this information. In the following webinar, I'll try and cover various aspects and questions that require both urgent and immediate attention. Some of the questions I intend to discuss are the low interest rates, whether it is treated as a contribution, and what was the ATO's considered view in the past. What is NALI and how is it defined? What is the ATO's stated position on non-commercial loans? And what were the ATO's previous views as published in various tax determinations from time to time? I'll also be looking at relevant case laws to emphasize certain points. Thirdly, what are the safe harbor provisions? The PCG 2016 that everybody is now talking about. What is it all about? Is it a public ruling? Does it automatically make income from non-complying loans NALI? Fourthly, what are the challenges for trustees in meeting the new guidelines? And finally, what possible actions can trustees take to ensure compliance with these rules? So let's begin the discussion with some background information. While borrowing from related parties have been around for some time, there have been a lot of discussions around what should be the appropriate terms for the arrangement. Regarding the ATO's views on borrowing from a related party, it states, and this is from the ATO's website published in July 2014, in quotes, The law does not prohibit the lender from being a related party. However, the SMSF must continue to comply with other legislative requirements. For example, if the SMSF must satisfy the sole purpose test and comply with the existing investment restrictions, such as those applying to in-house assets and prohibitions on acquiring certain assets from a related party of the fund. Here it is clear from the ATO's publication that related party loans per se does not violate any part of the SIS Act. Nonetheless, the ATO has had concerns about related party LRBAs with less than commercial rates of interest for some time now. It had issued Taxpayer Alert 2008/5 as a result, since its concern was low interest rates, which could be characterized as a contribution. This position has since been revised in a National Tax Liaison Group NTLG meeting held in June 2012, wherein it was decided that discounted interest rates would not be treated as an increase in the capital of the fund and therefore a contribution. Apart from this, there were a number of other concerns for a related party LRBAs with discounted interest rates, not least of which was the possible application of non-arm's length income, or the NALI provisions in short. The term NALI arises both in the SIS Act under Section 109 and Section 295-555 of the Income Tax Assessment Act 1997. In short, NALI for an SMSF is income derived from a scheme where the parties are not dealing with each other at arm's length and the income is greater than would be expected had the parties been dealing with each other at arm's length. NALI is taxed at the highest marginal rate, and that rate does not just apply to the excess but to all the income from the scheme. In addition, the rate is unaffected by whether the fund is in accumulation or in pension phase. The classic example given is where a related party is leasing a property from an SMSF and paying rent in excess of market rates. In this case, all the rental income will be taxed at 47%, not just the difference between what was paid and the market rates. Trustees can derive great benefit in a reduced interest rate as it results in a reduction in assessable income for the lender and an increase in assessable income for the SMSF. And as the SMSF usually has the lower marginal tax rate, the reduced interest rate results in a much lower overall tax liability. While the ATO has in the past published private binding rulings stating it would not apply the NALI provisions to a related party LRBA with a nil interest rate, it is clear that these rulings were made before the formation of their recent opinion as outlined in ATO ID 2014/39 and ID 2014/40 published in December 2014. Both of them have now been withdrawn, but they are still instructive in nature. The main facts from the IDs can be summarized as follows. In ATO ID 2014/39, the asset was shares in several listed companies. The lender was a related family trust. The holding trust was set up with all the standard clauses. Under the terms of the loan, the SMSF has a vested and indefeasible interest in the holding trust asset, is absolutely entitled to the holding trust assets, and has a fixed entitlement to the income of the holding trust. Under the terms of the loan, several $million were borrowed for a period of 20 years. However, the loans were paid as a single lump sum at the end of the term and are not in monthly installments of principal and interest. Moreover, the interest rates charged was nil and the LVR was 100%. I'll give you a few more seconds to absorb this information. In ATO ID 2014/40, the asset was real property. The lenders were two individual members and the loan amount was 500,000 over 15 years. The repayments were made monthly over a period of 15 years, but the interest rate was nil and the LVR was 80%. No personal guarantees were made in respect of either of the two loans. Now moving on, in each case the ATO went on to treat the incomes under both the cases as nully and taxed at 47%. Essentially, the main issue with both the loans was the 0% interest rate, with no principal repayments being required before the term end. The LVR was also set at very high limits, 100% and 80%, and that too was an area of concern for the ATO. ATO IDs 2014-39 and 40 have different facts, but the ATO's technical analysis in both is very similar. Both these IDs were issued after several similar negative private binding rulings were made by the ATO on this subject. Firstly, for nully to apply, the first criteria that needs to be fulfilled is that the SMSF must have acquired its fixed entitlement under a scheme being considered to be a series of steps undertaken to give rise to an LRBA. The ATO concluded that the SMSFs acquired their entitlements to the income of each holding trust under a scheme, and the ordinary and statutory income derived as a beneficiary of the holding trust through holding that entitlement is derived under a scheme. Secondly, the other criteria was that although both the parties were in an arm's length relationship, the crucial question was whether the parties dealt with each other as arm's length parties. The ATO referred to the federal court judgment in Allen and Anor versus the Federal Commissioner of Taxation, or the Allen case, on a number of occasions. In the Allen case, broadly, the facts involved a discretionary trust making around a 2.5 million distribution of a capital gain to a unit trust that had been amended to receive the distribution. The capital gain was then on-distributed to the SMSF as a unit holder. The SMSF argued the capital gain was not income but capital under Section 273 of the Income Tax Act 1936, which is the erstwhile provisions or the former equivalent of the nulli provisions under Section 295-550 of ITAA 1997. The SMSF lost as broadly. The federal court held that Section 273 applied to an assessable capital gain as the term income in Section 273 should be construed in context. The ATO relied on Allen's case. It considered the term arrangement in Section 273, which is the same as the term scheme in Section 295-555 ITAA 97, which is defined as any arrangement or any scheme, plan, proposal, action, course of action, or course of conduct, whether unilateral or otherwise. The ATO IDs extract the following from the Allen's case, in quotes. Ultimately, the series of steps undertaken by Mr. Allen, who is the member of the SMSF and the trustee of the discretionary trust, in directing the trustees of several trusts, including the superannuation fund, led to the results that the superannuation fund received both a fixed interest in the unit trust and the relevant distribution of income from that unit trust. The court also held that each ownership or beneficial interest was directly the consequence of an arrangement to which the various trustees were parties. Further, the court said that was clearly so, given that the creation of the structure and the flow of funds was orchestrated in line with the legal advice that had been obtained by the taxpayers. In quotes close. In our present case, ATO ID 39 and 40, the Commissioner concluded that the parties did not deal with each other as arm's length parties in both the cases. The ATO factored the following as the main issues that affected the outcome for the decision. Firstly, the lender was not being compensated for either the opportunity cost or the additional risk by not charging interest, particularly since the limited recourse nature of the loan posed an additional risk for the lender. Secondly, the loan-to-value ratio was higher than what arm's-length dealing would have specified. Further, no additional security compensated for the additional risk posed by limited recourse borrowing. Thirdly, the lenders did not seek personal guarantees from the members of the fund as security. Financial institutions lending on a limited recourse basis will quite often seek a trustee's personal guarantee or a third-party guarantee for the loan to increase their security. It is clearly permissible, and the guarantor, who would normally have a right of indemnity against the SMSF trustee, is therefore limited to the rights relating to the acquirable asset. And finally, for ATO 39, it was specifically pointed out that only a lump sum payment at the end was required instead of regular periodic principal payments. For these reasons, it was concluded that nulli provisions would be invoked since the parties did not deal with each other at arm's length. In addition, the ATO was of the view that since no arm's length lender would have advanced money on those terms, no income would have been derived by the fund, and therefore all income was to be treated as nulli. Here the ATO does confirm that not all related party LRBs give rise to nulli. The ATO is likely to apply scrutiny to related party LRBs where the terms of the loan, taken together, and the ongoing operation of the loan are not consistent with what an arm's length lender would accept in relation to the particular borrowing by the fund trustee. The points the ATO are likely to consider in that context are the nature of the asset, the amount of loan, the terms of the loan-to-value ratio, the interest rate, the nature and frequency of payments, any additional security. In order to ensure that nulli does not arise, the onus is upon the fund trustee to ensure that proper documentation is kept to be able to demonstrate that the terms of the loan are consistent with what an arm's length transaction would entail. Now moving on to the PCG 2016-5 itself. The previous determinations caused great concern among SMSF trustees with related party borrowings. How could they now be sure that their arrangements won't fall foul of the nulli provisions? In recognition of this, the ATO published guidance on this issue in April 2016 in the form of the Practical Compliance Guideline, or the PCG 2016-5. Till date, it is not a public ruling, meaning that it is not binding. Primarily, it is designed to be a safe harbor protection for SMSF trustees with related party loans under an LRBA. The guidelines provide protection for trustees of SMSFs to ensure that their related party loans is treated as arm's length, and any provisions from the asset is not to be treated under the non-arm's length income or the nulli provisions and taxed at a penalty rate of 47%. It is clear from the guidelines that if an arrangement is not consistent with the safe harbor terms as specified in the guidelines, it does not mean that the arrangement is automatically deemed as non-commercial. In that case, what actually happens is that the trustees will then have to demonstrate that the arrangement was entered into and maintained on terms consistent with arm's length dealing. After publication of these guidelines, the ATO received a significant number of individual requests for an extension of time, and in reviewing these requests, the ATO has extended the 30th June 2016 deadline to 31st January 2017 to ensure that the loan is either on commercial terms or complies with the safe harbor guidelines. The PCG also contained relief for LRBAs already in existence, and the ATO stated that it will not take compliance action against trustees for LRBAs for the 2014-15 years and earlier, provided that the principal and interest payments are on an arm's length basis for the 2015-16 financial year, and by 31st Jan 2017, either the LRBA is on terms that are consistent with arm's length dealing, or the LRBA is brought to an end. It is interesting to note that only real property and listed shares or units are covered in the guidelines. For example, if an SMSF trustee has borrowed from a non-bank to acquire a specific class of units in, say, certain platinum managed funds, what action could the SMSF trustee take? Many think of such an investment as a listed security, but technically it's not. Perhaps even more controversially, what to do if an SMSF trustee has borrowed to acquire units in a related trust such as a Regulation 1322C unit trust. Given there is no safe harbor available, the ATO's comments from December 2014 are more important than ever. The gist of the message is that the onus is now on the trustees to document the arm's length nature of the loan. This may prove difficult when there is no readily available market information and quotes and proposals from third parties. Indeed, some may even not wish to continue their related party loans and may even prefer to refinance with a bank. Apart from this, a written and executed loan agreement is also a must-have in such a situation. Moving on again, the guidelines specify compliance along 7 areas, which are interest rates, term of the loan-to-value ratio, security, personal guarantees, nature of payments, and frequency of payments. Taking them one by one, here interest rates may either be fixed or variable in nature. If fixed, the maximum term for the loan is 5 years and interest rates are 5.75 per annum for real property and 7.75 for listed shares. Moreover, the terms of the loan is the remaining term of the loan calculated as a 15 or 7-year maximum period. For instance, if the original loan was taken on 1st July 2013 for real property, then the new term for the loan on 1st July 2015 should be 13 and not 15 years to account for the 2 previous years of the loan being in existence. Similarly, if refinanced through another loan agreement, the new term of the loan will be the maximum term being 15 years less the balance of expired years of the loan's existence. LVR is 70% for property and 50% for listed shares. Registered mortgage or charge is required for both asset class, and monthly payments of principal and interest are required. It is also clarified that personal guarantees are not required. Some practical issues with the application of the guidelines may be shown with the help of an example from the guidelines itself. Here, a complying SMSF borrowed money under an LRBA on terms consistent with Section 67A of the SIS Act. It used the funds to acquire commercial property valued at $500,000 on 1st July 2011. Let us assume that the lender here is a related party. The details of the arrangement are as in the slide. The value of the property, 500,000, had subsequently risen to 643,000 on 1st July 2015. There is clarity in the guidelines that the market value of property as on 1st July 2015 may be used to determine the maximum loan amount. Based on 70% LVR of 643,000, the maximum loan amount is 450,100, which means that the SMSF needs to repay the balance of the 49,900, which is the 500,000 of the original loan less the 450,100, which is the current maximum loan amount. as on before the new deadline. The balance of the loan term is 11 years, which is 15 years less the expired years of the loan. The interest rate of 5.75 per annum applies from 1st of July 2015 to the 30th of June 2016. The SMSF trustees must determine and pay the appropriate amount of principal and interest for the year. This calculation must take the opening balance of 500,000, the remaining term of 11 years, and the timing of the 49,900 capital repayment into account. Further, the SMSF must review and amend the existing loan agreement to incorporate the new term and register a charge over the real property. Now, coming to what trustees can do under the new rules, there are essentially three methods which trustees can use to comply with the new rules. Firstly, ensure the terms and conditions are consistent with the safe harbor provisions. Here, the SMSF could alter the terms of the borrowing arrangement. There are some practical issues which we will cover a bit later through examples in the webinar. Alternatively, the trustees could refinance the loan with a commercial financier, settle the original loan, and pay all associated costs. Whether the original loan remains in place or not, trustees must ensure that the relevant principal and interest are paid for the 2015-16 year. Thirdly, very unlikely, pay out the LRBA. This is not a plausible solution, especially when the loan is of a large amount. Here too, interest and principal repayments must be made for 2015-16. Finally, I cannot stress how important it is to note that to be able to demonstrate that NALI does not arise, a fund trustee entering into an LRBA with a related party borrower should obtain and keep documentation that enables them to establish that the terms of the loan are consistent with arm's length dealing. Moving on to some challenges for the trustees going forward. The main challenges are the maintenance of the low loan-to-value ratio, the loan repayments for the 2015-16 year, and also mortgage stamp duty issues. Let us look at these issues through some examples. In example 1, say for instance, a property was valued for $1 million and the related party loan was also $1 million on 1st July 2013 with 100% LVR. Then on 1st July 2015, the value of the property had increased to 1.1 million and only 20,000 was shaved off the loan, which meant that the remaining loan amount was 980,000 on that date. With a 70% LVR, the amount of loan must now be reset to 770,000, which means that 210,000, which is the 980 less the 770, must be repaid together with monthly EMI amounts of 8,934 times 12, the principal plus interest, for 2015-16, which works out to 107,208. The total repayment then works out to 317,208, which is the 210,000 principal amount plus the 107,208 principal plus interest payment for the year, which is indeed a very large sum. This brings us to the obvious question: does the SMSF have the cash to pay the debt? If not, the, the members of the SMSF must make sufficient contributions so as to make the repayment possible. Alternatively, there may be a debt forgiveness of 210,000, which would be treated as a contribution as per ATO tax ruling TR 2010/1. Further, it must also be ensured that the non-concessional caps are not breached, and in certain cases, for example, when members are over 65 years and do not meet the works test, there is a real danger that this strategy might just not work. A further challenge is the 500,000 lifetime non-concessional cap, which was announced by the government recently. In instances where a loan had a loan-to-value ratio which was greater than the maximum allowed, one of the options was to make the repayments sufficient to bring it in line with the maximum LVR and to treat the same as a non-concessional contribution. However, the Treasurer, Scott Morrison, has stated that the government will offer some relief from this cap where the non-concessional contributions are required by the SMSF trustee to bring an LRBA which was in place before the budget in line with the safe harbor provisions as outlined in PCG 2016/5. This will come as a welcome relief for most trustees. When an SMSF borrows from a bank and a related party, for instance, same example as before, but with slight changes in facts. The value of a property on 1st July 2013 is 1 million. Assuming, for instance, if the loan from bank was 800,000 with 80% LVR, the balance of 200,000 was a related party loan. Let us further assume a bank interest rate of 5% and the term of loan of 20 years. Assuming 36,000 of principal was shaved off the bank loan in the 2 years, the outstanding bank loan on 1st July 2015 is 764,000. The related party loan on 1st July 2015 still stands at 200,000 with 0% interest rate. This means that no principal repayments were made on that loan. Continuing with that example, then on 1st of July 2015, the value of the property had increased to 1.1 million. So with a 70% LVR, the amount of loan must now be reset to 770,000, meaning that the total related party LRBA must be reduced to $6,000, which is the 770,000 less the 764 being the bank loan. The related party LRBA loan payout will be the balance of 194,000, which is the 200,000 less the 6,000 plus principal and interest. Further, a registered mortgage will be required for the property, which will not be possible since the bank would already have a mortgage over the property. Again, these are some of the reasons we feel will make a mixture of LRBA bank and related party loan impossible going forward. Another example, what if the interest rates are less, say less than 5.75 per annum for real property? Let's just say 4.75 per annum. The NTLG superannuation meeting in June 2012 had this to say regarding lower interest rates. Yes, a lower than market interest rates or the absence of a requirement to pay interest on money loaned to the trustees by a related party will not prevent the arrangements from being a borrowing for the purposes of Section 67A of the SIS Act. The ATO recognizes that while the obligation to pay interest may evidence the existence of a borrowing of money, it is not a necessary feature of such a borrowing. Paragraph 48 of SMSF ruling 2009-2. This stance was further vindicated in ATO ID 2010-162. Again, and we've spoken about this before, the onus is on the SMSF trustees to prove that they can source funds at that interest rate or else comply with PCG 2016/5. If the funds were to be audited, an existence of an exceptional trail of documentation to prove that loans at such rates were available to the SMSF at that point in time will be required. Let's consider another scenario. What if the interest rates were 8% and greater than the threshold 5.75% per annum as mentioned in the guidelines? The ATO has in the past clearly indicated that Section 62 and Section 109 of the SIS Act would be breached where interest rates were paid were greater than market rates of interest. SMSF ruling 2008-2 cites several examples of breaches of Section 62 of the SIS Act, one of which was the excessive interest rates paid to related party borrowings. Moving on to the fourth example, or the unsafe harbor. What if the lender is a related private company? Where the lender is a related party company, there is a great risk that Division 7A will become applicable. Trustees would therefore also need to ensure that the loans comply with the ATO benchmark interest rates as well as the guidelines itself. Another example, what if the terms of the loan were 25 years instead of 15 years? In a situation where the terms of the loan for a real property related party borrowing is 25 years instead of 15, SMSF trustees will then need to vary the loan agreement to reduce the term to 15 years less the expired years of the loan being in existence. This has been previously covered in the PCG 2016/5 example. Finally, registered mortgage. And what is to be done with the registration of mortgages? Here the SMSF trustees will need to register the mortgage over the property with the Land Titles Office for $136. For the information, the stamp duty on mortgages in New South Wales has recently been abolished from the 1st of July 2016. Finally, to recap on the main points of the discussion, first, the ruling is not public and therefore not binding in nature. However, the trustee will then have to demonstrate through proper documentation that the arrangement was entered into and maintained on terms consistent with arm's length dealing. Second, the deadline for compliance has been extended till the 31st of January 2017, which is big relief for most trustees. This means that the trustees now have 7 more months to bring their LRBAs in line with the guidelines. Thirdly, government will offer relief from a recently announced NCC lifetime caps of 500,000, where the non-concessional contributions are required by the SMSF trustee to bring a pre-existing LRBA in line with the safe harbor provisions as outlined in PCG 2016-5, which was covered previously. And finally, it is also worth noting that the NALI provisions will not be applied where the loan is sourced from a commercial lender, even if the terms do not align with the requirements as outlined in the PCG. There are several challenges in meeting the conditions as set in the guidelines. At the same time, there is clarity in what is actually a non-arm's length loan, for which one needs to be thankful. The purpose of this webinar is to share an understanding of the new rules so that we can fix existing situations and devise new strategies for our clients going forward. This brings us to the end of the webinar. Thank you for attending the webinar, and I really hope that this discussion was helpful. If you have a related party loan arrangement through us and wish to restructure them in line with the guidance, we've uploaded some templates of minutes and application to vary the loan agreement in the free admin document section of Trustdeed and online SMSF audit. Further, my email is agni@trustdeed.com.au, and you could also forward some queries out to me. Any feedback or topics to consider for webinar discussions in the future would also be very valuable interaction. Once again, I really appreciate your attendance and enjoy the rest of your day. And bye for now.